And you'll notice the setup is a little different today because we're using the hearing room system, the built-in system, which is a new technology here from yesterday. It's a different screen than I used to get.
Yeah.
Okay, there we go. All right.
Live transcript.
Yeah. Thanks.
Tracking. So yeah, I think you're good to go.
All right. Excellent. Thanks, Man. All right. So we have that much set up. So if people were joining Zoom just because the live stream wasn't working, it's on now. Makes no difference which way you connect, but I just saw people kind of joining us in a big wave here at 10. So let me just get the rest of the people here in. So I was just curious for Sam Green, are you affiliated with a party? Just wanted to get your appearance noted on Zoom, on the Zoom screen. If anyone else knows Sam Green?
No, I was just looking to join on YouTube and I didn't see it there.
Okay. Member of the public?
Yes.
Okay, well, you definitely welcome to stay on here or use Zoom. I'm going to just mute your mic for now.
Okay.
Thanks. Okay, and Josh Sultenberg, just curious if you're affiliated with a party or a member of the public.
I believe member of the public, correctly.
All right, I'll just mute you and you can stay on if you like. All right, I think we're good to go. So let's get on the record. Just want to welcome everyone to docket 9300 DR 106, the verified petition of Vote Solar of Distributed Energy Resource Systems in Wisconsin. Okay, this is Mike Newmark, Administrative Law Judge. With the PSC, welcome everyone to our hybrid, the second only hybrid and in-person or in-house public hearing here, a party hearing session today. We are taking evidence from the parties today, and we'll also be having a public session, which will be solely on Zoom. Will be on November 2nd at both 2 p.m. and 6 p.m. We're also receiving public comments in writing through the commission's website or by US mail. The deadline for those comments is Wednesday, November 9th. So far, we have 19 comments on file. So that's the basic introduction here. We just wanted to check with parties in terms of appearances, keep debating how to do this in an efficient way. Now that we're in multiple locations, I think the easiest thing, I'm just going to go down the list and have whoever is affiliated with the party just give us your name. And I think we have that already recorded by the court reporter, So I'll do this off the record, and this will just give her a chance to double check her own list. So let's just start through the list alphabetically and be off the record. So first for Cub.
Kara Coburn Ferris with the Citizens Utility Board.
And okay, can you turn is your mic off?
I'll bring it closer.
Yeah,
Is this better?
yeah, there we go.
Okay.
It's close. There we go. It's a little confused, but we're getting there. Okay, so go ahead. I'm sorry. Try that again.
Kara Coburn Ferris with CUP.
Okay, thanks. And next on the list, the city of Milwaukee.
Good morning. This is Assistant City Attorney Tom Miller on behalf of the city of Milwaukee.
All right, Clean Wisconsin.
Good morning, Your Honor. Brett Cordy on behalf of Clean Wisconsin.
All right, anyone else for Clean?
No, just me, Your Honor.
Okay. Customer First Coalition.
Jordan Hamiden of Michael Best and Friedrich.
Okay.
Brian Rood representing Customers First.
All right. Eagle Point Solar.
Jim Pullen here for Eagle Point Solar. Excuse me, Judge. I was trying to unmute myself.
That's fine, no problem. Not sure why we're not. I'm just curious, is your video screen on?
It is.
It is, huh? Okay, not seeing you there, but that's maybe not, I don't think it's your fault. I think it's just something. Not working quite right. Okay, we'll keep going. Fair rates for Wisconsin, for Wisconsin's Dairyland Incorporated.
Good morning, Justin Chasko, Frederickson and Byron.
Okay, just want to mention you are kind of low on volume. If you're expecting, I don't know if you'll be expecting to do much talking, but just make note of that if you need to.
Thank you.
Anyone else for fair rates?
No, Your Honor.
Great Lakes Utilities.
Richard Heineman from Boardman Clark on behalf of Great Lakes Utilities, as well as the Municipal Electric Utilities of Wisconsin, and also WPPI Energy.
I may repeat those too.
Yeah, sorry, I didn't know how you wanted to do it.
Local 420, and you're muted, just so you know.
Alex Tetzloff, Business Manager. Thank you, Your
All
Honor.
right. Let me know if the room volume gets too loud. I'm just turning it up here. Madison Gas and Electric.
Your Honor, Brian Kleinmeyer, staff from Genie.
Thanks. The munis, municipal electric utilities, any other people involved here?
I believe we do have others calling in.
Tim Heinrich, President and CEO.
Okay, I see you there. Thanks. NSP.
Good morning, Your Honor. Mara Ashman appearing on behalf of Northern States Power Company.
Okay. And we do this, don't usually do commission staff last, but I'll stay in order. So go ahead.
Sophia Rogers, Assistant General Counsel with the Public Service Commission.
All right. How about Solar Energy Industries Association?
Yes, this is Jean Armstrong on the behalf of the Solar Energy Industries Association.
Okay, Vote Solar.
Good morning, Your Honor. We have a couple attorneys here, and then we have our witnesses on as well, Mr. Kenworthy and Mr. Robigo. So on behalf of Vote Solar, Nikhil Vajaker of the law firm Keys and Fox.
Morning, Your Honor. Tim Lindell on behalf of Vote Solar.
Good morning, Your Honor. This is Erica McConnell with the Environmental Law and Policy Center on behalf of Vote Solar.
Okay. All right, great, thanks. Walnut Way Conservation Corp. Okay. Webco, oh, I'm sorry, Wisconsin Electric Cooperative Association. Is that
Justin
also-
Chasko again.
Okay.
Thanks, Your Honor.
Yeah, okay, so now Webco. Get through the Webco list here. Okay, so I guess I have listed for Webco as well as the Quarles and Brady attorneys. Is that, yeah? Is it, you are representing both? Okay.
Yes, Brad Jackson and Patrick Proctor Brown of Quarles and Brady also represent Webco and Wisconsin Public Service.
Okay. Wisconsin Power and Light.
Good morning, Your Honor. Zach Ramirez, appearing for Wisconsin Power and Light Company. Also, on behalf of Wisconsin Power and Light Company in the hearing room are Drew Carden and Michael Graveldinger.
Okay. Wisconsin Public Service Corp. Okay, and Brad Jackson and Patrick Proctor Brown.
Yes, sir.
Wisconsin Utilities Association. Again.
Brad Jackson, Patrick Proctor Brown of Quarles and Brady.
Okay. And WPPI.
Good morning, Tom Hanrahan with WPPI.
Okay, great, thanks. So I'm going to try to view speakers here. It doesn't. We'll try it this way for now, and we may have to go to the gallery view where you see everyone instead of just the speaker. For some reason, it wasn't switching back and forth like it's supposed to, but let's hopefully that'll work once it warms up or whatever it needs to do. I don't know. Okay, so let's stay off the record for a minute, and we can discuss the offered evidence list. It's probably, I think we can copy our process from yesterday and get into witnesses that we can excuse because there's no cross. At this point, I see that there's only one witness there's pending questions. Is that still the case? Kenworthy?
Yes.
Okay. Anyone else have questions for any other witness?
Yes, Your Honor, I'll have questions on Sir rebuttal for Mr. Robigo.
Okay, so witness will be appearing. Okay, that's fine.
And we'll have an objection for Customers First Coalition to the exhibit they offered.
Okay, we'll get to that. Thanks. All right, so at this point, it looks like we have only one witness subject to cross, and one witness, well, we may not be able to admit all that currently offered evidence. So we will withhold affidavits for those witnesses, but otherwise, actually, we did have one question for Cub witness Singletary before we ask about whether we can move that documents in.
Thank you, Your Honor. We did fail to file and serve that Exhibit 1 Singletary. It's the same exhibit that we filed in the 9300 DR 105 docket. I think council are familiar with it, and I did distribute that this morning and file it on IRF. And I'm not aware of any objections, but it was very short notice.
Yeah, we can ask for that. But I was just curious. So was it? I thought maybe it just not been filed, but was it also not served?
It was not served either.
So let's get on the record. And we did, I did notice an anomaly in the Cub filings that Exhibit Cub Singletary 1 was not filed with the commission. And just speaking with Cub counsel, we now understand that it was not served as well onto parties. However, that document is the same as the Cub Singletary 1 filed in the 9300 DR 105 docket. So knowing all of that, I'm just going to ask if there are any objections to the receipt of that document into evidence. No? Okay, so we can allow that document to be received, although it had not been filed or served prior to today. So we'll just need to have that filed according to the revised testimony deadline. Besides that, I didn't see any anomalies. I should ask though, we can do this off the record. Any corrections to the list, documents I might have missed, et cetera?
Your Honor, this is Justin Chasko. Can you hear me okay?
Yes, we can hear you.
Better now,
Yes.
thanks. Mr. Quackenbush, we need to remove the hyperlinks. I apologize for that. And in that process, we noticed the title to his testimony also has an error in it. So we were intending to correct that as well. It would just be to the title of the testimony.
Okay, all right, great. Yeah, I missed that. Thanks for mentioning that. So is the 105 docket correct, or should I expect to see a change?
It's correct in that docket.
Okay, all right, that's fine.
Thank you.
All right, so again, no other corrections to the offered evidence list. Yeah.
Your Honor, not a correction to the list, but we found one non-substantive error in Mr. Robigo's rebuttal that we plan on addressing during direct.
Okay, that's fine.
And then, Your Honor, I had a question about your comments on the offered evidence list. It's not, I think we have everything we need, but I think there's a comment in there about the exhibits to the petition. Should we deal with that right now?
Oh, okay, yeah. If you have a question about it, sure.
Yeah, well, I just want to make sure that I have it right. So I think your request is for us to take all of the exhibits to the petition and possibly the petition itself, and then make it one PDF and file it as an exhibit.
Yeah.
And would that be an exhibit to Kenworthy or?
It need not be. You could just call it like it's labeled here VS petition.
Okay.
It's just kind of a generic
okay, I see that.
style for that. Yeah, because it
We'll
need
do
not
that.
come in through a witness. It's just it's basically a pleading, but in order for it to be in the record, I'd like it to be an exhibit.
Sure.
And this way we can manage the documents better that way.
Got it. So we'll label it exhibit VS petition, and then we'll
VS
just file it
VS
after that.
petition.
Yeah.
Yeah, this just helps us organize those documents better.
Thank you.
Anything else?
I'm not sure this is the right time or not, but in terms of offered evidence, we have an agreement with Vote Solar to admit into evidence some discovery responses that were referred to by Mr. Rabago in his rebuttal testimony. And specifically, they are the responses.
You know what, let's get on the record for that,
Oh, I'm
because
sorry,
I think we'll put those in as exhibits then,
Okay.
if that's okay. So,
That's fine.
so if you just back up a little and
No
put that on
problem.
the record. Yeah, so go ahead.
Your Honor, we have an agreement with Vote Solar to offer and admit into evidence the discovery responses that are referred to by Mr. Rabago on page 15, footnote 29 of his rebuttal testimony. I believe there are 5 of them. So we would offer those by stipulation.
How long how big are those documents? Do you think we can put that into one exhibit? I mean, 20 megabytes of information.
I think we need to split them up. I think some of them have voluminous
Okay,
attachments.
all right. And that's okay. All right, so there's 4.
I believe there's 5. 5.
So the next available number is Rabago 5 through 10. Rabago's exhibits 5 through 10, the data request responses that are cited on rebuttal, VS Rabago 14, 15.
Let me just ask, does that include the exhibit you guys served?
So I was just about to ask, Your Honor said 5 through 9, then this would be?
There was 5 of them, right?
Yeah,
So 5 through 10. It might
9.
9, I think.
9. Oh, yeah.
Yeah,
All right.
count
Oh, whatever. 5 through 10. 5 through 9.
Oh, so that does include the one you guys.
Does
served last
include,
time.
which we had.
And so we'll serve those, file and serve them today.
Yes. Okay. You want that's fine. Request. And so that includes, so all of them are cited in testimony. Is that
Correct.
Okay. Okay, great. Anything else? All right, so let's get back to our list of witnesses. So it appears we have agreement that we can excuse witnesses Singletary, Rude, Johnson, Quackenbush, Adams, Heinrich, Tetzlaff, Burrows, Graves, right? Graves, Heiser, and Simon. It's up to
We'll have Simon verify.
Okay, thanks. It's up to parties whether they want to call those witnesses, but I'll accept those documents by affidavit, the verifications by affidavit if they choose. Otherwise, those witnesses are excused. And we can start with our first witness. So anyone in person right now, or they're both online?
Both online, Your Honor.
Okay. I don't.
I'm right now.
Oh, so why don't you call your first?
Thank you, Your Honor. Vote Solar calls witness William Kenworthy.
Good morning.
Good morning.
All right, good morning. I'm going to swear you in, so please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, go ahead. Go ahead.
Can you please state and spell your name for the record?
William Kenworthy, William, Kenworthy, Kenworthy.
Thank you, Mr. Kenworthy. And could you please state the name of the party that you represent in this proceeding?
I represent Vote Solar.
Mr. Kenworthy, did you prepare and cause to be filed direct testimony and 7 accompanying exhibits in this case?
I did.
And did you prepare and cause to be filed surrebuttal testimony in this case?
Yes.
And is that testimony true and correct as of the time it was written to the best of your knowledge?
Yes.
Do you have any corrections that you'd like to offer to your testimony today?
Not at this time.
If asked the same questions today, would your answers to those questions be the same?
Yes.
Thank you, Your Honor. The witness is available for cross-examination.
Okay, I believe there are questions.
Yes, Your Honor.
Go ahead.
Good morning, Mr. Kenworthy. My name is Brad Jackson. I represent the Wisconsin Utilities Association.
Good morning.
Good morning. You've identified Northwind Renewable Energy Cooperative as the tax sponsor of the family project that's referred to in your petition, correct?
Yes.
Can a cooperative take advantage of federal investment tax credits and bonus depreciation?
I'm sorry, Your Honor, and this isn't necessarily an objection, but if just a request, if Mr. Jackson could just point us to, if he's looking at a particular spot in testimony, I might appreciate just catching up.
I'm not referring to his testimony at this point.
Okay, or responses or discovery responses.
He identified the tax sponsor in response to 1 WA interrogatory 5.
Thank you.
Okay, so let's go off the record for a second. Yeah, to the extent, to the consequence may be a little bit of a delay here, but I'll want to see that as well. So is that something that's been filed? Do you have a birth number for that?
447119. And Page 11.
I'm sorry, could you repeat the number of the interrogatory?
It was 1 WUA INT 5. It's at the bottom of page 11 of responses that were served on September 12th.
Okay, and I could put that on the screen as well.
Okay.
And so, yeah, so you confirm that, yes, the cooperative is the tax, oh, I'm sorry.
Yes.
So you confirm that the cooperative is the tax sponsor, and my question was whether a cooperative can take advantage of federal investment tax credits and bonus depreciation.
I'm not an attorney, so I don't have it. I have nothing to say about that. My understanding is that under the new investment Inflation Recovery Act or Inflation Reduction Act, that is possible, but I don't know what arrangements Northwind had set up to for their financial to take advantage of the tax credit.
But you apparently understood what a tax sponsor for a solar project of this type is.
Yes, I do.
Okay, what is your understanding of what a tax sponsor is?
A taxable entity that's eligible to monetize the investment tax credit.
And is it your understanding that a cooperative is such an entity?
Your Honor, I'm going to object there. It's asked and answered.
Overruled.
I'm not. It was represented to me that Northwind believes they're eligible to take advantage of the tax credit, and so that's I don't have an understanding or a background in what entities are and are not eligible for the tax credit.
Do you at least understand that as between Northwind and the family, that Northwind, as the tax sponsor, receives the federal tax benefits for the project?
Yes.
At page 4 of your direct, line 19, you liken the lease that you've attached to your petition as similar to an automobile lease. Do you see that?
Yes.
And if I could turn your attention to the lease that you attach to your petition as Exhibit 1. And this is the lease that Northwind has apparently entered into with the family associated with the family project.
Give me a moment.
With the family project is how it's referred to in the petition.
Correct.
Just wanted to clarify. So
It's Exhibit BS1 to the petition.
Yep. Okay, I'm sorry, which page?
I'd like to start on page 2. At the very top. To your knowledge, with a typical car lease, does the lessor insure, maintain, and repair the car as part of the lease at no additional cost to the customer?
Your Honor, I'm going to object to that as outside the scope of Mr. Kenworthy's testimony. Mr. Kenworthy hasn't testified to the details of the terms of an automobile lease. He's just made an assertion in his testimony that the two types of agreements are similar. I think we're getting into territory here that's specific to the terms of an automobile lease.
Well, if you can't explain why the lease is similar to an automobile lease, then I move to strike the testimony.
I'm sorry, I couldn't hear the judge's response.
Couldn't hear the judge. Oh, I overruled the objection, so you may answer.
Okay. Can you repeat the question, please?
To your knowledge, with a typical car lease, does the lessor insure, maintain, and repair the car as part of the lease at no additional cost to the customer?
I don't know the scope of all available car leases, but no.
Similarly, does the lessor provide a performance guarantee in terms of how the car will perform?
There are certain parameters of the vehicle that are warranted under a car lease, yes.
But that'd be from the manufacturer, wouldn't it?
I can't speak to that. I don't know.
In section 2 of the lease, the term is stated at 12 years. And I believe it can be extended by up to 8 years. Is that typical for a car lease, that kind of term?
I don't know what car lease terms are widely available. I've heard shorter terms on car leases.
Are you aware of any car lease that's available for 12 years?
I don't, I mean, I'm not aware of any, no.
If I could turn your attention to page 3 of the lease, section 5, entitled Lease Obligations.
Okay.
And if you could see 5 sub A, Romanet 3, one of the customer's obligations is to keep the panels clean. Under a typical car lease, is the customer required to get the car repaired and keep it clean?
Your Honor, I'm going to object again here. I think I understand the point of these questions, but again, I think we're straying into questions that are specific to the terms of automobile leases. Mr. Kenworthy has already testified in response to cross that he isn't aware of the full range of the scope of automobile leases that are out there.
Okay, overruled.
Well, there's no panels on a car, so, but I am aware that there are maintenance requirements for vehicles under lease frequently.
Romanet 7 on page 4 requires the customer to allow the lessor to inspect the system with reasonable notice. Is that a typical provision of a car lease?
I'm not aware whether it is or not.
Does a typical car lease limit the customer's use of the car to primarily for personal, family, or household purposes?
I'm not aware whether it does or not.
Is this a typical provision of a car lease? The customer may not not do anything, permit or allow to exist any condition or circumstance that would not cause the car not to operate as intended.
Can you point to the section of that?
That's Romanet 9.
I'm not aware whether car leases require or conditions or not.
Okay, I just off the record. You just need to repeat that, and if you can get maybe closer to your microphone.
All right, I may have been covering it with, I'm sorry, I may have been covering it with my exhibit. I'm not aware whether they require similar conditions or not.
Turning to page 8, section 13, loss or damage, subsection A. Under a typical car lease, does the lessor, quote, bear all of the risk of loss, damage, theft, destruction, or similar occurrence, end quote, to the car, unless the customer is grossly negligent or intentionally damages the car?
I'm sorry, which Romanette were you referring to there?
13A.
I'm not aware. I don't know.
So it doesn't seem like you're knowledgeable enough about the terms and conditions of automobile leases to make the assertion that you make on page 4 of your direct, are you?
Objection, Your Honor, mischaracterizing the witness's testimony.
Sustained.
I'm sorry, am I supposed to answer?
No, you don't need to answer.
Thank you.
Okay, so you'll be glad to know I'm off the car lease thing. But I do have other questions about the lease. If you could turn to page 6, section 8, entitled transfer.
All right.
As I understand it, the original developer that installs the system has the right to assign, sell, or transfer the system or the lease to a bank, large company, or other significant financing party. Is that correct?
That appears to be what it says. And
the
I'm not
developer,
an attorney, but yes, I think that's common practice in the industry.
I'm sorry, you're gonna need to repeat your answer. We're having trouble hearing you again.
I'm sorry. I can try. Would it help if I tried headphones?
Yeah. Whatever you can do, yes. And if we need to have you call in as well as use the internet video, we can do that as well.
Let me try this.
All right. Is this better?
Yes. Yeah, why don't you try that? Yeah.
Yeah, please. Can you repeat the question, please?
Yes, I understand that the original developer that installs the system has the right to assign, sell, or transfer the system or the lease to a bank, large company, or other significant financing party. Is that correct?
Judge, this is Commissioner Hebner, and that didn't come through at all on the Zoom, the transcription service. Thank you.
I thought that might have been the case. Thanks for pointing that out. Let's have her read the question.
Question, and as I understand it, the original developer that installs the system has the right to assign, sell, or transfer the system or the lease to a bank, large company, or other significant financing party. Is that correct?
And I'm sorry, I get the page and section number again, please?
Page 6, section 8.
Okay. Yes, that's my understanding.
And the developer can do that without the customer's consent, right?
Yeah, I believe so, yes.
And if there is an assignment, the original developer has no liabilities or other obligations under the lease, correct?
I'm not aware of the legal obligations that a developer would have if they assign the lease.
Can I direct your attention to page 7, still in the same section? it states, quote, lessor shall be released from all its liabilities and under other obligations under the lease, end quote. So if the lessor assigns the lease to a financing party, the lessor no longer has any liabilities under the lease, correct?
That appears to be what it says, yes.
And it's the financing party in that case that is now the owner of the system, correct?
Yes.
And yet it also says that the lessor, the original installer, retains the obligation to maintain the system under the limited warranty, correct?
Yes.
That obligation is not assigned to the financing party, correct?
Correct.
So at this point, the lessor, who has the obligation to maintain and repair the system, no longer receives any lease payments, gets no revenue from the system, correct?
Right. Correct.
The lessor remains obligated to maintain and repair the system and pay refunds if the system does not produce the guaranteed amount under the limited warranty, correct?
Can you refer me to that section that you're referring to?
Yeah, it's the last sentence of that section. This assignment does not change lessor's obligation to maintain and repair your system as set forth in the limited warranty.
Right, that's correct.
So if all of that is true, then that we've gone through, what incentive does the lessor have to maintain and repair the system?
My understanding is that typically the owners of the systems will contract with local providers of services to maintain and service the system if necessary.
Okay, so the original developer would enter into a contract with the financing party to maintain and repair?
Yes, that's typically the way I understand it works.
Even though the financing party has no obligation to maintain or repair the system.
The financing party still owns the system, so it's in their interest to maintain it.
Okay. What happens if the system needs repair, but the lessor is no longer in business? What does the customer do then?
Your Honor, I'm going to object. This is asking the witness to speculate on something that's not in either the exhibit nor in his testimony.
Well, it's a logical outcome of the terms we've just discussed. There's clearly a distinction between the obligations that the owner has and the financing party has. And I'm trying to explore whether there are things that can fall through the cracks here. And I think it's a reasonable, logical outgrowth from my prior question.
Okay, it's all overruled.
So I have not been involved in the transactions on the backside of solar development, but the way that I understand it works is all the obligations are transferred to the new owner of the system, and the new owner of the system is responsible for meeting the obligations under the financing agreement, and that the host would contact whoever system it's on would contact the new owner of the system who would be obligated to provide, repair or service under the terms of the agreement.
Yeah, I'm sorry. I'm just not seeing that in this language because the lessor has assigned the lease to the financing party, not the limited warranty. And the assignment does not change the lessor's obligation to maintain and repair. Am I reading that wrong?
Your Honor, this is a question. I'm not sure what Mr. Jackson is reading. So if you could refer me to that.
I've been on section 8 for about the last 5 minutes.
Sure. So then that last part that you just said about what you're reading and whether you were reading that right, I think the question was whether you were reading something right. And I'm wondering what it is that you're reading.
Section 8.
Okay.
It's not long.
Then, Your Honor, I would just request that that last question be read back.
Okay, let's do that.
Question, I'm sorry, I'm just not seeing that in the language because the lessor has assigned the lease to the financing party, not the limited warranty, and the assignment does not change the lessor's obligation to maintain and repair. Am I reading that wrong?
So, Your Honor, given the readback, I would object because at this point, I think counsel is testifying. He's not reading directly anything from the terms of the lease. So if there's a question about the terms, I think that question was answered by the witness. But what counsel appears to be doing here is recapturing the terms of the lease in a way that is testimony, not a question.
Okay.
I'm trying to communicate.
My sense of the question was that there's an absence in the lease. And I think what Attorney Jackson was trying to say is where is the provision that would satisfy the condition that he's investigating rather than I can't point. What I think he's saying is that he can't point the witness to the provision that he's looking for. And
Yeah,
is that
what I'm really following up on is that the witness testified that if the lessor was not around to repair, that you could go after the financing party. And that's what I'm not seeing in this language.
Your Honor, if I might respond to that, the witness was not testifying that that's what the arrangement of this lease agreement was. The witness's response was that he believes it's his understanding that such arrangements are typical. So I think that there's some mischaracterization of the witness's response here.
I think counsel is now testifying.
well, I believe the witness did state something similar to that. But at this point, I think to the extent the witness knows one way or another, I think that's on the record. I'm not sure what else to pursue here rather than.
Well, can I just confirm then, sir, is it your testimony that if the lessor does not follow through on its obligation to repair the system under the limited warranty, that the customer has recourse against the large bank or other financing party that has been assigned the lease?
Yes, that's my understanding.
And then can you point to a provision in the lease that designates that?
I can't point to a provision in the lease. My understanding is that's something that is part of the terms of the transfer of ownership to the secondary financing.
Okay, so your understanding is it would be contained in a separate document?
Yes.
And that document's not offered for the record at this time?
Right. Correct. I'm sorry.
Okay, thanks. Okay,
So the lease that you've attached to the petition is not the full, does not present the full accounting of the transactions around this family project, correct?
Objection, Your Honor. That is mischaracterizing
Well,
the
it's a
testimony.
That's a question.
So overruled.
I would say the lease does represent the full extent of the transaction around the lease.
But you just indicated that there is some separate transaction or documentation between the lessor and the financing party that is not part of this document, correct?
I think it says that it's possibility. They may transfer. The
Right,
terms of that,
asking-
the terms of that transaction are not in this document.
Okay, if I could turn your attention to the next section, 9, ownership of the system, tax credits and rebates.
Okay.
Is it your understanding that the owner of the project owns any and all tax credits, incentives, renewable energy credits, green tags, carbon offset credits, utility rebates, and any other non-power attributes of the system?
That is the terms of this lease, yes.
Is there any requirement that the owner, the developer, pass along any of the economic benefits of those non-power attributes of the system to the lessee?
No.
If I could turn your attention now to the performance guarantee and limited warranty, which is Exhibit 2 to this lease.
Okay, off the record.
Page, starts on page 15.
I'm there.
VS2.
VS1.
Oh, okay.
I apologize. There's a preliminary question that I forgot. If we go to page 3 of the lease.
Okay.
So we're all together, same page?
Yes.
Yes, Mr. Kenworthy, as I understand it, I'm looking at because it'd be 4B, the monthly payment section. The payments under this lease, at least after the first monthly payment, the monthly payments after that are fixed. They're the same amount each month, correct?
That's how this lease is structured, yes.
Okay. Now, if I could turn you to the limited warranty. And actually, I'll go to page 16.
Okay.
Off the record. So it's the performance, is it section B again, back to that, or?
Page 16. Yeah, that table.
Oh.
Yeah.
Oh, back on, thanks.
Okay. So in terms of the guaranteed and expected output of the system under this limited warranty, we see that the output of the system is expected to go down by some amount over time, correct?
Yes.
Is it correct to conclude then, because the amounts are blacked out here, that the guaranteed price per kilowatt hour would increase over the term of the lease?
I did not testify about what the rate of the guaranteed price is, and it was not part of the exhibit.
Well, it is part of the exhibit.
Well, I mean, it's not. It's not pertinent to whether or not I don't know. Can you restate the question, please?
Yeah, so I think it's simple math, but I just want to confirm that if you have a fixed monthly payment, and yet the kilowatt hours guaranteed and total go down over time, so that the guaranteed price per kilowatt hour would necessarily have to increase over time, correct?
The guaranteed price per kilowatt hour times the total kilowatt hour is not designed to offset the lease payment.
So the guaranteed price per kilowatt hour is not based on the monthly payment?
It's not, to my understanding.
What is it based on?
It's a price that they set to compensate the customer if the system doesn't perform under the performance guarantee.
Is the guaranteed price per kilowatt hour, is that fixed throughout the term of the lease?
I'm not aware of how that is set in this arrangement. I don't think it was designed. My understanding is it's not typically designed to compensate the customer and to be equivalent to the annual monthly payment or the monthly payment. It's designed to offset the customer for loss of use of the system at approximately what the expectation is for what the energy that they will have to purchase is.
Is it based on some forecast of what the market value of the power would be? Is that what you're saying?
That's typically what it would be based on.
But you don't know what it is for this contract?
No.
Do you have a version of this contract that is not redacted?
I do not.
Okay.
Well, okay, so I just wanted to, this may have been my oversight because typically I don't allow documents to be filed only in redacted form. My assumption or perhaps miscalculation here was that the only thing that was being redacted was customer identity, which I guess is known anyway, right? In this case, but and I did not scroll all the way down to look at what else may have been redacted. And so I believe it's appropriate for the commission to see the full document and that should be filed in a confidential process. And I don't know if that's going to shed any more light or less, or just confuse things more. But I think we should have the full document on file for the commissioners to review. And I think like we did yesterday, where I had parties will then on their own deal with who is acceptable parties or persons to review that full detail. I'll let parties work that out, but it should be filed confidentially. It should be filed confidentially and served upon appropriate parties. Once if an NFA confidentiality agreement needs to be formed before that gets served, that's okay with me. But the commission should get the full version. So that could be filed within the 3 days, 3-day window to file additional exhibits. You want to just mark that. So this is the VS1 document. If you could just include the confidential and public versions in the new VS petition exhibit.
And Your Honor, we're willing to accept it on an attorney's eyes only basis as we did.
Okay,
yesterday.
that works. Okay, so any comments on that? Are we in agreement?
Just a question,
Yeah.
Your Honor. So is the request that the unredacted document be filed, but that, do you mean completely unredacted, unredacted with respect to this line of questions on the guaranteed price per kilowatt hour, unredacted except for customer information?
A completely unredacted version would be filed with the commission under confidentiality request. And then I would accept a copy of the current version as the public version, but they both need to be filed simultaneously on our system in order for it to accept the confidential request. And you'll see that when you get to the online form, it'll require both a confidential version, and you'll want to highlight the items that you believe are confidential, and then redact, in the public version, redact the same text that you're claiming is confidential.
So just again, that's just as a matter of process.
Sure.
I think we were going to file all of the exhibits to the petition as exhibit VS petition.
Yes.
We just do that as VS petition public, VS petition confidential.
Yes, there need to be 2 copies of the entire petition. That's and I'm not sure, I guess so I guess I don't remember looking at every document attached to the petition. So if there are other documents that have been redacted, why don't you go ahead and unredact those in the confidential version as well, and then keep the redactions all in the public version of the petition exhibit.
The other unredacted document would be the interconnection agreement, which has the interconnection agreement, which has the customer's identifying information and insurance information and things like that, that we would not want to be made public.
It wouldn't be made public.
Right.
Yes. Right. Okay. All right. And so I think Attorney Jackson had offered that the service of the document be attorney's eyes only. So I'll agree with that. Just in terms of which parties should receive that document, I'll leave it up to parties to agree to that. And if there's no current confidentiality agreement between those parties, then I would subject the service of those documents pending an approved and agreed to confidentiality stipulation for that. Okay. So any more questions on the VS1?
No further questions, Your Honor.
Any other questions? No, at all. Okay. All right. So I'll clear up my screen here. Any other cross for this witness? Okay. So I did fail to mention, I did this yesterday as well, but I did want to acknowledge that we have Commissioners Nowak and Huebner at the hearing. So we would accept questions from them as well, should they choose to just chime in if you ever have a question. We'll accommodate your timing on that. And so no other cross, any redirect?
Your Honor, we will have some redirect from Mr. Kenworthy. Could I request 10 minutes to confer with Mr. Kenworthy and my co-counsel?
Yeah, we can do that. You don't want to do that. Yeah, usually we don't let you do that. So you can speak with your co-counsel, but not with the witness.
Understood.
Yes, 10 minutes?
Yeah, is that request granted? Can we just confer?
You can confer with the co-counsel, yes.
Okay, thank you.
Okay, thanks. All right, so we'll go into recess for 10, be back at 11:20.
Judge, I think the chair is on as well.
Oh, okay. Yes. All right. So yeah, I didn't see her, but yes, looks like I'm informed that we can put this on the record. Chairperson Bach is also in attendance. Okay, so to go into recess, we'll mute and we will
May
put up the
I go
notice.
off camera, Your Honor?
Yes, go ahead. Yeah, you can go off cameras, mics. Yeah, I would say just mute. Oh yeah, mute the hearing room.
Confirm on mute.
Got it. Okay, that's crazy. Okay,
Yeah, you just never seen that before because
Yeah.
You've always been on the
it's integrated. Yeah.
yeah. Well, you've been always been
we go. Thought I took care of that. All right, sorry about that. Okay, let's get on the record. So we took a little break here for Vote Solar Council to confer with each other. So I just wanted to confirm witness Kenworthy, while we were in the recess, did you confer with council? Oh, you're muted. This one.
No, Your Honor.
Okay, thank you. And I just wanted to note that, yeah, the request to confer with council, have the witness confer with council before redirect. I think there's never really been explicitly asked, but it's rare that I require a witness to remain on the stand when we're in person while attorneys confer with counsel. I think it's just a matter of trusting that that doesn't happen, or that if it does happen, no one's been objected before. I've not inquired about that in the past. So just wanted to state that in the context of this case. Let's continue with redirect. Go ahead.
Thank you, Your Honor. Just a couple questions of redirect. Good morning, Mr. Kenworthy.
Hello.
Do you recall a line of questions this morning regarding a comparison between automobile leases and DER leases that you made at page 4 of your direct testimony?
Yes.
And do you still have that testimony available to you?
Yes.
Okay. Do you agree that the comparison that you made in your direct testimony between automobile leases and DER leases is that both involve a monthly payment?
Yes.
Mr. Kenworthy, do you recall a line of questions this morning regarding the maintenance of systems in a situation where a lease has been assigned?
Yes.
Mr. Kenworthy, do you agree that word of mouth is an important means of marketing for a solar company?
Yes.
And would a solar installer have a strong incentive from a reputational standpoint to make sure that its system is operating correctly?
Absolutely. Yes.
Mr. Kenworthy, do you recall a line of questions this morning regarding paragraph 8 in the lease agreement, which concerns transfer?
Yes.
Has the Northwind lease been assigned?
Not to my knowledge. No.
Thank you, Mr. Kenworthy. No further questions.
Okay. Thank you very much. You're excused.
Thank you.
So should we move on to a witness for Vago?
Thank you, Your Honor. Vote Solar calls Carl Robigo.
Good morning, everyone. Just checking that you can hear me okay?
Let's go off the record. Let me see if I can find, is your video on?
Yes, it says it is, and I can see my face.
I see you there. Yes.
There we go.
Okay, perfect. Yeah, so it's your sound quality is okay. It's a little low though, as we've been having that issue. Possibly just putting the microphone closer.
Okay. All right.
Okay,
Let me try one adjustment here.
Okay.
See if I can. All right. How about this? Is this better sound quality?
No, it hasn't really changed very much, but I think
okay.
I think we can try to live with it for now.
Okay. I'll project.
So, all right, great. Yeah, if you could just speak as clear and loud as you can. All right, so let me swear you in. Raise your right hand, and do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, go ahead.
Thank you, Your Honor. Good morning, Mr. Robigo.
Good morning.
Can you please state and spell your name for the record?
Yes, my name is Carl R. Robigo, and it is spelled K-A-R-L, middle initial R, last name Robigo, R-A-B-A-G-O.
And you are appearing on behalf of Vote Solar this morning, correct?
That is correct.
And did you prepare or supervise the preparation of the rebuttal testimony offered in your name in this proceeding, as well as 2 attached exhibits?
Yes, I did.
And did you prepare or supervise the preparation of the surrebuttal testimony offered in your name in this proceeding, as well as 1 attached exhibit?
Yes, I did.
And did you prepare or supervise the preparation of offered exhibit VS Rabago 4 that was served on parties yesterday?
Yes, I did.
In reviewing your testimony in preparation for examination today, did you find any errors that require changes to your pre-marked testimony or exhibits?
One small error on page 22 of my rebuttal testimony at line 17, in which the text reads actions taken primarily State's Attorney General. And there should be the word by, BY, between primarily and states, so that the phrase reads actions taken primarily by State's Attorneys General. And there was a second issue on naming of numbering and marking of pages, but did you guys already take care of that?
Not specifically, but yes, we understand that's a correction that needs to be made. So if we can have the refile include both, correcting both errors, that would be great.
Thank you.
We will do so, Your Honor. Thank you. Mr. Rabago, as corrected, are the facts that you state in your testimony true and correct to the best of your knowledge?
Yes.
Do the opinions and conclusions expressed in your testimony reflect your professional experience and best professional judgment?
Yes, they do.
Thank you, Mr. Rabago. Your Honor, we have some short oral testimony we'd like to give in response. Should we do that at this time?
Yes. So we have, I just want to be sure we have already marked and we've received, because it's been verified now, Rabago exhibits 1 through 3. I believe there is a pending objection to Rabago 4, but why don't you proceed and we'll have the objection come in when counsel feels it's appropriate. Go ahead.
Mr. Rabago, did you have an opportunity to review Customers First Coalition witness Rude's surrebuttal testimony in this proceeding and the attached exhibit CFC Rude 8?
Yes, I did.
Do you agree that witness Rude's surrebuttal addresses and exhibit 8 is a letter from Secretary Thompson of the Wisconsin Department of Transportation to Secretary Buttigieg of the U.S. Department of Transportation?
Yes, I do agree.
Do you agree that the letter addresses whether there is a need for a legislative change to provide a clarification regarding the statutory definition of a public utility as it applies to EV charging stations?
Yes, that's what the letter appears to do.
Do you agree that the letter responds to a notice of proposed rulemaking at the U.S. Department of Transportation regarding the National Electric Vehicle Infrastructure Formula Program?
Yes.
And have you reviewed the notice of proposed rulemaking that is the subject of that letter?
Yes, I don't know every line of it, but I do. I've seen some presentations on it and I've reviewed through the notice of proposed rulemaking.
Thank you. And is that notice of proposed rulemaking the same exhibit marked as exhibit VS Rabago 4 served on parties yesterday?
That is the Federal Register official filing of it. There's also circulating around an informal version and I think a formal version from the website of the Department of Transportation, but they all appear to be the same.
And I think this may be the appropriate time for Customers First Coalition to interpose an objection to the admission of Rabago Exhibit 4.
Okay, I'll hear that now.
Okay, 2 grounds, Your Honor. First of all, it's untimely. The supplement here facilitating matters requires that those exhibits be filed no later than 1:30 on the day preceding hearing. It wasn't filed until, I believe, 4:51 yesterday. So it's a timeliness thing. The other thing here is, I mean, this document speaks for itself. It's a piece of it's law or proposed law. And at least in the voir dire, I heard before, I didn't hear any foundation that this witness would have any firsthand knowledge of facts relevant to the interpretation of that. I have no argument with council citing it in their brief, but I don't know that this witness has anything to offer. That would be probative.
Your response?
Yes, Your Honor. It's not supplemental testimony. It's testimony that is in response to the last round of testimony provided by Customers First Coalition Route. So, for example, it's different than the supplemental testimony request made by WUA a day or two ago, asking to supplement their own testimony. This is in response to the last round of testimony. With regard to the fact that it's in the Federal Register and we can cite to it, I don't disagree with that per se. I would like to ask Mr. Rabago one question about the subject matter of this proposed rulemaking and offered the exhibit simply to support what the proposed rulemaking is about.
Okay, I guess in terms of foundation, though, how is his expertise related?
I'll build that foundation as well, Your Honor.
I'll allow it to proceed. If you have a further objection, you can raise it. But I think as far as we sit here right now, I think it's okay to proceed on this. And yes, it's an official document that can just simply be cited in a brief, but we typically do just to complete the record and give commissioners the convenience of having a document in the record instead of having them find it in terms of finding a citation in a brief. I think on that basis, it's a valid to offer that as an exhibit. Whether there's any countervailing reasons, and we haven't really addressed yet, but just in terms of putting in a document that may also just simply be cited in a brief, that's typically our practice when it's reasonable to do so. But why don't we proceed with the voir dire and your questions and see if there's any further objection.
Thank you, Your Honor. Mr. Rabago, do you agree that the purpose of that proposed rulemaking is in part to support the construction of publicly accessible EV chargers?
Objection, that's leading. I think we need to have open-ended questions here at this point.
All right. I'll sustain that. Can you?
Sure. Mr. Rabago, what is the purpose of the proposed rulemaking as you understand it?
As I understand it, the Department of Transportation is proposing regulations which would establish the NEVI program, the National Electric Vehicle Infrastructure Program. I think if I have that acronym correctly, it relates to installation, operation, and maintenance of EV charging infrastructure, interoperability of EV charging structure, traffic control, and a number of other factors associated with the installation, operation, and availability of a public electric vehicle charging network.
Off the record, you're going to need to slow down a little bit.
Sorry. Yeah, it's a bad habit.
Okay. We'll if someone raises an objection, we'll have to stop anyway. So just by going fast won't help. But our court reporter's fingers have to protect. So so why don't we start? I don't know where you ended up.
Sure. I'll summarize again. Yes, I am familiar with this. This is a rulemaking from the Federal Highway Administration of the U.S. Department of Transportation. This rulemaking sets out the terms and conditions, the rules associated with the National Electric Vehicle Infrastructure Program, a program designed to result in the installation, operation, and availability of public charging facilities for electric vehicles. It includes things like requirements related to installation, operations, maintenance, interoperability, and other data and other things associated with electric vehicle charging networks.
Thank you, Mr. Rabago. Do you have any experience with the operation of EV charging stations?
Yes, I do. In fact, about 10 years ago, I installed a public electric vehicle charging network. I supervised it when I was a vice president for distributed energy services at Austin Energy, one of the largest municipal electric utilities in the nation. We installed about, I think it was 145 stations geographically distributed across our service territory in the city of Austin that were publicly available charging stations. In addition, about that time, I also bought my first EV I've now had 3. I currently operate one. I privately charge it in my home, and I publicly charge it on public charging networks. And I also have 3 electric bicycles that I charge privately.
What are some examples of EV charging stations that would be relevant to a program supporting publicly accessible EV chargers?
Yes, I can tell you from personal experience, but also from looking at this around the country in various places. A publicly accessible EV charging station is something that people with EVs, electric vehicles, can drive up to, gain access to sit their vehicles there while they're gaining a charge. Examples, I've used them at grocery stores, at Walmart parking lots, and since I'm about planning a road trip to go see my mom, I have been looking at apps that show where public chargers are along interstate highways, at rest stops, truck stops, things like that.
I'm going to interpose an objection again. I don't see how this is relevant or responsive to a letter that was submitted by Mr. Rood simply to demonstrate that there was a communication from the Wisconsin Public Service Commission that a change in law was required in order for Wisconsin to meet the requirements of this proposed rulemaking. I'm not hearing any evidence that's relevant to that point or responsive to that point.
Your Honor, the next question takes us there.
Okay, go ahead.
Would you agree that EV charging infrastructure at those types of EV charging stations is dedicated to one specific customer's use?
No, that's not the exact opposite of the description. While there may be arrangements behind the scene between, for example, the owner of the parking lot and the constructor or the financer of the charging infrastructure, the very point of public EV charging is it is publicly accessible. You have to make sure that parking lot is publicly accessible. So the idea is that any unspecified but qualified by version of technology and ability to pay customer may make use of that charging station simply by driving up, making the appropriate payment, and connecting their vehicle.
And from your review of the record in this proceeding to date, is the equipment comprising the family project in Vote Solar's petition accessible to the public?
No, it is not. Just as you're not allowed to bring your electric bike or car to my garage to charge it there. My understanding, the family project is intending to be the primary user. The generation at that facility would be for their use, even though there may be incidental exports to the grid.
All right. No further questions, Your Honor.
All right, thank you. Okay, I think that's fine. I don't know if that really added anything to the record that wasn't already there. So I do respect CFC's motion, but I think at this point I can accept the document for what it's worth, and the testimony probably duplicative of what's in the record, but that happens sometimes. So are we ready for cross then?
Yes, Your Honor.
Okay, any cross? No?
Sure.
Oh, yeah, go ahead.
So, Mr. Robigo, you testified just a moment ago that a distinction in your mind of public EV charging versus the family program offering that's the subject of the petition is that the EV chargers are available to the public, correct?
Yes, the service that the equipment provides is designed, installed, and operated to be available to any member of the public who has the qualifying technology and payment system and wants to draw that electricity from that charging equipment.
And do you know whether the family program that's the subject of the petition would be restricted from anybody in terms of who it's provided to?
I do not know.
I mean, once it's installed, it's available only to the person whose property it's installed on, right?
It is.
I think you said that.
Yeah, the idea is that it is operated behind the meter, as we say in the industry, and that it is meant to primarily offset local consumption behind that also occurs behind the meter?
But there's no limitation that you're aware of about how many people that system could be provided to in Wisconsin.
How many people there's only one customer behind that meter is, you mean other systems?
Yes, other systems. There's no limitation on how many systems would be provided in Wisconsin, is there?
I might need you to be a little bit more clear. You mean technical, safety, interconnection, any kind of limitation, or do you mean, could you please clarify?
Yeah. I'll try to ask him more simply.
Okay.
Is the proposal to provide this to just one customer in Wisconsin?
The
system.
The system. This system for the family project, excuse me, this system for the family project is one system to serve one customer behind that one customer's electric meter, their interface with the electric utility distribution system.
And is there any limitation that you're aware of on how many of those systems will be sold to how many customers?
Different customers and different systems.
Without
I do,
limitation?
yeah. I do not understand there to be a proposal by Vote Solar in its petition that there be a limited number of such systems installed. But based on my practical experience in the electric utility industry and with the concerns of distribution system managers and operators, there are always technical and practical limits to the infinite installation of generating equipment, just as there's limitations on in the installation of load equipment on a grid.
And you have no idea what those are in Wisconsin right now, right?
I do not.
Thank you. That's all I have.
Okay, thanks. Redirect.
Sorry, my microphone is on now. One quick redirect question, please. Mr. Robigo, under the facts in the petition, would a solar company's PV systems be dedicated specifically to each host customer?
Yes, that's the structure that I understand is in there.
Nothing further, Your Honor.
All right. Okay, well, thank you. We have testimony and the corrections have been cited. Okay, thanks very much. You're excused.
Thank you.
So before we press on, I did have back to a preliminary matter, but we did get our witnesses that we had questions for out of the way. Rest of the witnesses we do have one more pending, right? They'll take the stand, but I did want to just address some issues that we overlooked as a preliminary matter. First of all is the we're on record, right? The request to accept supplemental exhibits from WUA, and in this case, there's 4 proposed exhibits. So I did send out a preliminary ruling on one in the offered evidence list, that being exhibit WUA4, which is a duplicative of exhibit CFC RUD 7. So I would, if that's true, I believe it's true, I would deny that the acceptance of WUA4. So I just want to make sure that's correct.
I believe it's true.
Okay.
Thank you, Anna.
And then in terms of WUA exhibits 1 through 3, they're similar to the documents we received in the 9300 DR 105 case. And I was going to accept those documents pending any objections. At this point, are there any objections?
Same concerns as in the 105 document, but no objections.
Okay, and just restate that concern so it's on the record here.
Our concern was that these supplemental exhibits relate to testimony filed by witness, WUA witness Graves, incorrect, and could have and possibly should have come in as exhibits to his testimony so that everyone had an opportunity or more of an opportunity to review. But with that said, we understand that part of the motivation here for these exhibits is to gain clarity on what can and cannot be used in briefing, and understand this was a conversation that we had at yesterday's 105 docket. I hope I don't have to repeat all that. For that reason, not going to offer an objection here.
Okay, thanks.
And
So just off the record, did you hear that? Okay, good. Yeah, back on.
I would just say, because there's a characterization of our witness's testimony, we disagree with that. These are documents that are related to the status of the law in Wisconsin from 1907. So Mr. Graves doesn't have any knowledge of that and wouldn't be part of his testimony.
Okay, thanks for the clarification there. Okay. So the other outstanding matter, we did address it in the 105 docket, so I want to do that here as well. Relates to the issue of environmental review. It's a question I posed to petition opponents, so I'll do the same. I expect WUA to take the lead in that, but I would invite any other petitioner opponents to comment if they have a comment. So let me read out that question. So I don't know why it's so small today. Let me just, there we go. Okay, so the commission has deemed the proposed action to approve the petition as a type 3 proposal under Wisconsin Administrative Code, section PSC 4.10 sub 3. In their responses to the petition and the pre-hearing conference, petitioner opponents raised an issue for hearing whether the commission should prepare an EA or EIS with respect to the proposal. However, petition opponents have offered no evidence to indicate that the preparation of an EA or EIS is warranted. Therefore, provide a brief statement on the petition opponent's current position on the matter.
Yes, I can do that, Your Honor. And thinking about it some more, I went back and looked at the commission's order on the interlocutory appeal with respect to the schedule, and it would appear in that order the commission quite definitely rejected that view, our position on that on the merits. So I guess I'm not sure it's still an issue at play in the case. Having said that, if we are to address that further, we would do so in brief on a matter of law, and we did not offer additional testimony or evidence on that issue in the hearing.
Okay, great. So I just wanted to confirm the reason for offering no evidence. That's the basis of that question. Okay. All right, so we can move on. And I think we just have one more witness. Is that correct?
I believe so, Your Honor. Wisconsin Utilities Association would call Commissioner Simon to the stand.
All right, so we'll make that available. Good afternoon. Very good. Raise your right hand. Oh, you can sit.
Oh, no, I'll stand.
Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
All right, have a seat. Let me just get this adjusted here. Something. Okay, great. Go ahead.
Thank you, Commissioner Simon. Would you please state and spell your full name for the record, please?
Timothy Allen Simon, TIMOTHY, ALANSIMON.
Thank you, Commissioner. Would you please, did you prepare or cause to be prepared direct rebuttal and surrebuttal testimony in this matter?
Yes,
And did you prepare or cause to be prepared 13 exhibits accompanying that testimony?
yes.
And are those exhibits true and correct to the best of your knowledge?
To the best of my knowledge, yes.
And if I asked you the questions contained in your direct rebuttal and surrebuttal testimony today, would your answers be the same?
Yes, they would.
Commissioner Simon is available for cross. Thank you.
Any questions? No, hearing none. Thanks very much. You're excused.
Thank you.
All right. Welcome to Wisconsin.
Really, really great.
All right. It's always good to hear. Okay, anything else we need to take care of? No, we have the schedule, rest of the schedule set, so I believe we're good. Just expect your corrections and filings and refilings, et cetera. And at this point, we're adjourned. Take care.